You move in together. You share a fridge, maybe a Netflix password, maybe even more. No wedding, no contract. But could you still be in a partnership? Maybe. Hi everyone, my name is Brenno Nel and I'm an associate here at Anja Opperman Attorneys. And today we are going to be decoding the relationship law that only shows up after the breakup, or even worse, after death. When it's suddenly too late to ask, what are we? So, what is a universal life partnership in plain English? Think of it as a life partnership contract that the law reads from your conduct. If two people both contribute, both benefit, and the relationship is geared toward building wealth together, a court can say, that looks like a partnership, even if you never wrote anything down. So how do people accidentally land in one? Well, it happens slowly. So you move in temporarily. You start paying for things together. Groceries, fiber, a deposit here, some renovations there. One of you focuses on a career or a business, while the other one of you focuses on keeping the home running, helping with admin, maybe raise the children. Your language shifts from mine and yours to ours. There's no paperwork, but there's plenty of evidence that you pooled your efforts and resources, which is exactly what courts look for. So here's a story that really drives this home. In Butters versus Mancora, a couple lived like spouses for nearly 20 years. He built serious wealth. She largely ran the home and supported the enterprise around him. But when they split, she argued that there was a tacit universal life partnership. The Supreme Court of Appeal agreed the partnership existed, and she walked away with a share of his net estate. The key takeaway: domestic and supportive contributions can absolutely count toward the same joint enterprise. And it's not just that one case. In Ponelat versus Shrepfer, the court confirmed the same test and even said an unequal division with the liquidator to set out the numbers, because contribution isn't always equal, but it definitely counts. So, what actually happens if a court says that you were partners? First, property. Assets built during the relationship can be divided. Not necessarily 50-50. Courts look at who brought what to the table. This might include money, labor, skills, or taking on the load at home. Second, maintenance after a breakup. So this is where people get caught out. Remember, South African law doesn't give unmarried partners an automatic right to spousal maintenance when they separate. Some litigants try for interim help in exceptional cases, but it's not a rule you can rely on. If you want support post-breakup, you need to agree to it in writing. Don't assume the court will create it for you. Third, if a partner dies, that's a different story. In the Bwanya case in the Constitutional Court in 2021, the court held that a surviving life partner who can prove a real permanent partnership with reciprocal duties of support may claim maintenance from the estate and may even inherit on intestacy. That's powerful protection when someone dies. But you still need to prove the partnership and the duty of support existed in the first place. Alright, so how do we avoid surprises? Start with a simple rule. Clarity beats litigation every time. If you want to stay separate, say so clearly and live that way. Put in a cohabitation agreement. This is very, very important. In that cohabitation agreement, make sure you say, we live together, but we do not intend a universal life partnership or a duty of support. Each keeps their own assets and income, and any shared purchase gets recorded in writing. Remember, keep your finances tidy. Separate accounts, label your payments clearly as loan, rent, or gift. And be deliberate about whose name goes on the house, the car, and the investments. Your conduct should match your words. Now, if you do want a fair share model, write that down too. We do intend a universal life partnership, limited to what we acquired together from this date. If we split, we divide things 50-50 or by contribution percentage. We agree to no maintenance or limited maintenance, whatever works for you. That one page can save you both 2 years of drama and a small fortune in legal fees. And please, please make a will. If there's a duty of support, plan for it. If not, say so. The Bwanya case helps survivors, but wills prevent fights, and make your wishes crystal clear. Alright, let's bust 3 myths before we wrap up. We've been together for 6 years. Doesn't that mean that we have a common law marriage? No. South Africa does not have common law marriage. The concept was abolished in 1926. Living together creates 0 automatic rights. You just need to prove an actual partnership. Myth number 2. After 3 years living together, are we basically married in the eyes of the law? No. 3 years, 10 years, 30 years. The duration doesn't magically equal a marriage. Time alone means nothing. What matters is whether you pooled resources and acted as partners building wealth together. Myth number 3. The house is in my name only and it's protected if we split, right? Not necessarily. Keeping the house in one name doesn't automatically shield you if your conduct screams joint enterprise. The law looks deeper than title deeds. If your partner contributed money, labor, or support that helped acquire or maintain that property, they might have a claim despite the paperwork. Bottom line, love is personal, but money is legal. If you're living together, the law might see a partnership, even if you never signed a thing. So pick your path on purpose. Write it down, keep records, and plan ahead. Okay guys, so if this benefits someone you know, please remember to share, like, and subscribe.